Thank you, Heather, for that introduction. As Heather mentioned, our offices are here in Roseville. I'm a certified specialist in estate planning, trust, and probate law by the state of California. I've been practicing for about 10 years. I'm licensed in California, Nevada, and Wisconsin. And so this is a great opportunity. So thank you, Heather, for allowing me to give you a little bit of information about estate planning and trusts and probate and what it all means, because I think there are a lot of questions out there that you don't always find the answers you're looking for. So at the end of this, I will have the link to my calendar. So if you want to book a free consultation with me, you're welcome to do that. And we can go over your individual questions too. And also, like Heather said, we will do questions and answers. So if you do have a question in this, you can type, for those of you who are on the webinar, you can type your question in the chat box and Heather will address those at the end. So without further ado, I will share my screen here. Let's see. Okay, so estate planning. So I have some mind-boggling news for all of you. When you die, your stuff is not going to come with you, none of it. So if you're like me, you don't spend a lot of time thinking about your own death. You probably think I'll deal with it tomorrow. But if you don't have a plan for your stuff, someone will, guaranteed. Your stuff will go to someone, somewhere, somehow. So what is an estate plan? It's a vital collection of these legal documents, including the living trust, a will, a durable power of attorney for property, HIPAA authorization, advanced healthcare directive, deeds, beneficiary designations, etc. But it's not only that, it's also your chance to leave your own legacy. What are your life and faith lessons that you want to pass down to your children, your grandchildren? It's an opportunity to do that with your estate plan. So in explaining estate planning, I've found that the best way to approach this is to go through the frequently asked questions that people have for me when planning for their incapacity and their death. So who needs estate planning? It's simple. Every adult with children, even without children, need estate planning. If you have any assets that are of significant importance, not of significant value, but of importance to surviving family, is being irresponsible without a plan. I have seen so many families get into arguments about, who's getting the coffee table. My law partner always tells the story of years ago, he had a family that there was some tangible piece of personal property that one sibling wanted, and another sibling didn't want that sibling to have. And of course, no plan was in place. So what happened is that one of the siblings burned the property and handed the ashes to the person who wanted the property. Like, the things can go wrong if you don't have it in writing. So the estate planning is not only for the wealthy, and think about who is making your medical decisions. I mean, if you're homeless, like literally living under a bridge, it's important to think about, who do you want to tell the doctors, okay, time to pull the plug. It's important to think about who is making these medical decisions for you. So what is a will? It's a legal document with instructions to be carried out after your death. So you name your beneficiaries. In a will, you name a guardian for your minor children if you have a minor child, and you also name an executor. And an executor is the person who's going to be administering your estate. So a will takes you to probate. A lot of people think that a will avoids probate. It doesn't. So a will puts you in probate. So that's taking your assets to court to transfer over to the beneficiaries. So what is probate? It comes from, the word probate comes from a Latin word probare, which means to test, try, examine, prove. In modern English, I'd call it a real hassle. The average probate proceeding in California takes about 16 months. That's over a year before all the assets can be distributed over to the beneficiaries. You have to publish notice in a newspaper. Your name, your date of death, your executor is all going to be in the newspaper. It's all public record. Every single pleading we file with the court is public record. So people, anyone can go into the courthouse and request to see your probate file. And what it will show is how much you had at your death that's subject to the probate court. It's showing all your beneficiaries addresses, how much they're getting, when they're getting it. It's kind of scary. It gives me goosebumps to think about that people have access to all of this. The chances for people to take advantage of that and take advantage of your children if you have nothing in place for them, if you don't have a trust set up for them. It's scary. So someone's going to be appointed personal representative of your estate. They're going to receive what's called letters testamentary. And those letters, about 3 months after we file the first petition, are what are going to give you the ability to, or your executor, the ability to handle your financial affairs. They basically can't act for about 3 months. In Sacramento, it takes 2.5 to 3 months before we get in. And now with the courts closed, with this pandemic, everything's on hold. So it's taking even longer, unfortunately. Attorney's fees are crazy high when we're looking at a probate. And this is why people want to avoid probate. This is why you hear avoid probate, avoid probate, avoid probate. Attorney's fees are crazy. So for a $500,000 estate, think about the value of your house. If it's, completely encumbered, if you have a mortgage for, the majority of your house, it doesn't matter. The court looks to the fair market value of the house and not the net value, how much, you'd be actually receiving for it if you were to sell it. They look to what it would sell for without looking at the encumbrances at all. So look at the value of your house, your bank accounts, your non-retirement bank accounts. Usually with retirement, you've got a beneficiary designated on there, but sometimes they don't, and it goes to the estate, and it's all part of this fee. So attorney's fees are $13,000. Executors' fees are the same as attorney's fees, $13,000. So you're looking at $26,000 for just potentially probating a $500,000 house. Where are you going to get the liquidity? Well, sometimes you don't have it. Your beneficiaries might have to sell the house, or if they don't want to sell the house, they're going to have to come up with the money somehow. You don't want to lean up on the property. Probate, like I said, no privacy. We have a really great tool on our website. It's a probate calculator, fee calculator. So you can follow the navigation from our website and just look at the probate fees. So you can type in, the potential value of your estate, and you can click enter, and then it will show you how much attorney's fees will cost. That is not including the publication fee. Publication is crazy high in California. It's like $250 to publish. Every document, every petition we file, which is at least 2 in a probate, is $435. Then you have to pay for a probate referee's appraisal, and that is, not cheap either. So you're looking at probably a couple $1,000s to just in costs alone to do the probate, plus the attorney's fees, plus the executor's fees if your executor chose to take them. They don't have to. So what happens now if you don't have a will? The state of California decides who gets your stuff. You don't want that to happen, especially if you have separate property, you're married, you want to make sure that your children, most people don't want their kids to inherit. They probably want their spouse to inherit. I had a situation where we had a man unexpectedly pass away from a heart attack in his 40s, and his wife hired us to be the probate attorneys. He had nothing in place. He owned a business. He had separate property of about $4.5 million, and his wife was not thrilled to find out that she only got a third. The other 2/3 went to his kids. Thank goodness they were not minors, so we didn't have to get a guardianship set up for them. But what we had to do is have the kids gift their $1.5 million, it was about that each, back to mom. They had to file a gift tax return each. It was way complicated. And guess how much attorney's fees for that were? They were about $60,000 for probating a $4.5 million separate property estate. Crazy. He could have paid a couple of grand to have, or a little bit more than that, to have a living trust prepared. And he could have avoided, his wife wouldn't have had to deal with any of this. It's mind boggling. So what is a living trust? Well, this is the probate avoidance technique. It's basically a super will. It's a bucket where you place certain kinds of assets and you have complete control over your bucket, and there's no court involvement, which is such a beautiful thing. Can you think about that? It's, you just, you pass away and your trustee is just taking over for you. There's very little that needs to be done in comparison to the probate process. Now, it's not completely without its, your trustee still has to do some certain things, but it's so much quicker, so much less expensive, so much more efficient for your beneficiaries to administer your estate when everything's in a trust. It's just so much easier for the trustee to handle. So what can a living trust do for you? This is such a cool thing. It can protect your beneficiaries, protect the inheritance your beneficiaries are getting from their creditors and from divorce. We can set up a lot of tools. We can set up a subtrust. There are different types of subtrusts, but what happens is you pass away and your beneficiaries inherit this subtrust. So for instance, my daughter's name is Ava. So in my trust is called the Kaminski Living Trust. So at my death and my husband's death, Ava would be getting a subtrust, and it would be called the Ava Kaminski subtrust under the Kaminski Living Trust. She's going to hold her assets that she's inherited from me and my husband in that subtrust. It's going to be protecting her from from creditors and from divorce, because we set it up that way. So it's a real neat tool that is a great asset protection vehicle that your creditors cannot get at the inheritance that you leave for your children. Also has a living trust, like I mentioned, quicker administration process than probate, and like I mentioned as well, no court involvement. So how can it be helpful at your death? As we talked about, no probates required, no published notices, no court dates, no statutory attorney's fees, no judge. So wonderful. What a wonderful tool. Who should you name as a trustee? I get this question a lot, like, who should I name? Don't just name the oldest kid. I just warn you, a lot of times when there is, when the family's dealing with, I've seen it on both ends. So when they come in to plan, the parents want to name their oldest child as the trustee if they're adults. I encourage you to think about that. Instead, I would name the family peacekeeper, the person in your family who, plans the family events, the one that makes sure that they talk to everyone, the one that just wants to keep the family a family unit. Don't just pick the oldest kid. It's not always the best idea. If there is tension in your family, I recommend looking to a professional fiduciary. California has a great selection of professional fiduciaries, and that's found on the PFAC website. It's PFAC. You could just Google it, and you can find a list of professional fiduciaries. Also, you can talk to your estate planning attorney and find out who they recommend. I have certain fiduciaries I recommend because I've worked with them and I know that they do good work. Not all fiduciaries are the same. You want to get someone who is vetted and who you trust, and also you can look, or you can go, have coffee. Well, once this pandemic is over, maybe you can have a Zoom meeting with your prospective fiduciary, but that's a good option too. All right. So if you have a living trust, you still need a will. This is a question I get all the time. Why do I have a will when I have a trust? Well, you always have a will when you have a trust, because a will is going to, when you have a trust, it's going to pour over your assets into your trust should you forget to fund something. Oftentimes at death, we find there's something that's not funded into the trust. How do we get it into the trust at death? Through that will. If we didn't have the will, everything would be going according to the law of intestacy. So it's important that you have that will. And how are your assets put into your living trust? So you title your bank accounts, your non-retirement accounts in the name of your trust. You title your house in your trust. We assist with the entire process of funding your trust, it's called. So for instance, in my own trust, it's the Kaminski Living Trust. Like I mentioned, everything I have is titled Kristin Kaminski, trustee of the Kaminski Living Trust, dated October 10th, 2012. So my house is titled that way. My bank accounts are titled that way. Now, vehicles are not. In California, we don't have to worry about that. So they are not. So you just keep your vehicles in your name and with your spouse if you have one, and only use or. You don't want and on the DMV title. You want or. So that's my trick to remember. Only use or on your vehicles. What other planning should you do, especially in light of all of this that's going on right now with COVID-19? You want to think about your incapacity. So think about your durable powers of attorney for property, advanced healthcare directives. If you have minor children, think about who's going to be taking care of them. If you're stuck in a ventilator, with a ventilator in the hospital for 2 weeks, you can't see them. Think about who you want to serve as your guardian. If you and your spouse have minor children and, something were to happen that both of you were unable to take care of them, that not only comes into play in your will, but also think about it, just if you're incapacitated and you can't take care of them. So you want your HIPAA, and how should you provide for your minor children? Think about guardians for them. Prepare a living trust that you can set up these sub-trusts. It can be a lifelong sub-trust for your kids. It's a really neat tool. And when do you need to update? I get that question a lot. If there are major changes in your life, like births, deaths of immediate family, change of trustees, and generally see your estate planning attorney every 3 years. Think about, the last decade in your life. A lot might have changed. I know that for me, I've gotten married, we've purchased a house, I've had 2 children, I've moved 2,000 miles away. A lot has changed in the last 10 years for me. Also, a lot has changed in the tax laws. There was a huge change in 2013. So if anyone has an AB trust, we're basically getting rid of those types of trusts these days. So we're restating trusts and amending those provisions to create a more simplified trust. And so talk to your estate planning attorney if it's been a while since you've had your estate plan reviewed. And so what can you do now? You're welcome to talk to me. I'm happy to chat with you if you're, a California resident. I also, like I said, practice and licensed in Nevada and Wisconsin, so I could certainly assist with the Nevada side of things too. I practiced estate planning there for 4 years before we relocated to California. You can feel free to schedule a free consultation with me using the link there. So with that, that's kind of my spiel about basics of estate planning, the differences between a living trust and a will. So Heather, I will turn it back to you.
Thanks, Kristin. Can you stop the sharing on your screen so that
Yes.
if someone has a question we can see?
Yeah.
A couple things I just wanted to point out, listening to you, Kristin, I really appreciate you taking your time today, is a perfect example that I've seen in estate planning when someone has a trust, and the reason for having that will attached is a lot of times when you refinance your house. Mortgage people do not like to refinance a house back into the name of the trust. They tend to move the house deed out of the name of the trust into your individual names, and then they refinance and they don't ever move it back into the trust. So the one big asset I've seen that a will has really helped has been I stopped it for you, Kristin.
Okay, thank you. Couldn't figure it out.
The big thing that I've seen that will has really helped is to get the house back into the trust if for some reason that hadn't happened. So I think that's a
Exactly.
big thing for almost everybody in California, especially if you own a home. In my opinion, there's no reason not to have a trust.
Mm-hmm.
It's a huge asset, and it will definitely put you into probate if you don't have the trust.
Mm-hmm.
The other thing I just wanted to reiterate is on the sub trust, I think you have to look at who your beneficiaries are. So I just like to use my family example. My mother has a trust. I have two siblings, both who have not necessarily had the same, made the same decisions in life as maybe I have. And so my mom actually has sub trust set up within her trust so that even though we're all adults and all 40 and older, when she passes, those assets are going to go into these sub trusts so that my sisters are protected from creditors as well. So I think that it's super important when you have young children, but I think you have to look at who is benefiting from your trust upon your death as well. And the thing I tell people all the time is the reason to have a trust, first and foremost, is control. You have control now. When you're dead, you're still controlling things.
Mm-hmm.
And so I think that has been, in my opinion, one of the big points that I like to make with clients. So does anyone have any questions today? It's been pretty quiet on the chat, but if anybody has a question, we'd love to answer them for you. We do really try and keep within the 30-minute window. I really appreciate Kristin taking all of her time today to spend with us. I know it's been crazy for her in this time right now, and there's no better time than the present to sit down and do your adult things. I had a client who they're in their early 30s and their trust got done, and they said, we feel like adults now. So I know talking about when you die is not something people like to do, but it is something that's going to happen to us guaranteed at some point. And so I think being prepared for that and having control over what happens once you're gone is huge.
Mm-hmm.
So I don't see any questions. So I just want to thank you all again for joining us. Huge thank you to Kristin for taking this time this morning.
Thanks for inviting me, Heather.
Yeah, we are again posting these to our YouTube channel. So if you haven't been there, please go and start following us. It's a new thing for us that we're excited about. We have a bunch of other events going on. There's a yoga class today at 4 o'clock. That's 30 minutes for beginners if anybody just needs 30 minutes to relax. But please share these with your family and friends. I think these are super important for our community right now with everything going on. So again, thank you so much, Kristin. Have a wonderful day, everyone. Thank you for joining us, and we look forward to seeing you at our next event. Thanks so much.